I see Mr. Bolin. We're just waiting for Mr. Lee. All right, Mr. Lee, Mr. Bolin, welcome. Mr. Lee, we are ready. You may proceed.
May it please the court. My name is Brian Lee. I am representing the appellant Jennifer Norden in this appeal. I would like to reserve 3 minutes of my time for rebuttal, please.
Very good.
This case comes to the court from a summary judgment that we believe was improperly granted to Walmart. As this court knows, while reviewing a summary judgment motion, a trial court cannot weigh the evidence or resolve disputed issues of material fact and even resolve inferences from either side. Walmart owed a duty to Ms. Norden to use reasonable care in keeping and maintaining its store in a safe condition and to warn her of any dangerous conditions. The evidence in this case shows from the plaintiff's side and proves that Walmart did not uphold that duty. And specifically that Walmart had not only—
we have a kind of an unusual situation here in that, unlike most cases, we actually have video evidence of the area where this incident allegedly occurred, which I think the judges would like to have video evidence of every argument we ever have, but we do have it in this instance. We also have a lower court judge who carefully, repeatedly went over that evidence and could find nothing to indicate actual or constructive notice such that summary judgment wouldn't be appropriate. So I would imagine you would agree that there is no actual notice in the record, and I'd like you to state your case as to why you believe there's any constructive notice.
Sure, Your Honor. And there is an argument, just so I'm clear in what I'm telling you, that we believe that there is an element of actual notice in this case. And the reason that is because of the fact that Walmart themselves sell, and they have 2 restaurants in this particular Walmart. They sell drinks in those restaurants. And so there are, one of the, we believe, reasonable inferences in this case is that the transitory foreign substance, essentially the water or a clear liquid that was there, one of the inferences is that it could come from that type of drink. And so if the case law that I've cited to the court is that if that reasonable inference would be adopted by the jury, that would be actual notice because of the fact that Walmart is actually creating the condition, essentially selling the transitory foreign substance. And we've put that in the brief. So I just wanted to make that clear to the court. That is one of the—
But of course, the record doesn't indicate in any way, shape, or form where this particular clear liquid came from.
It does not, Your Honor. But our argument is that we don't need to. And the reason that is because there is this question of inferences that you can stack. But you can only stack inferences if the underlying fact that you're now stacking an inference on is undisputed. We have that in this case. And the reason I say that is because we have an undisputed fact that there was liquid on the floor. And we also have a next undisputed fact that Ms. Norden slipped on that liquid. All the parties agree to that. That's undisputed. And so the inferences that we then can stack upon that, we say that that liquid either came from either an employee or someone walking through to the store. Walmart says something different, but we can have that inference. That inference is reasonable and it is allowed because of the fact that we have the foundation that's undisputed. And so getting to what the trial court did.
By the light of that argument, then, as a matter of law, if you have liquid and if you have a slip and fall, as a matter of law, by the lights of your argument, there is always an issue for the jury, which seems to be veering into the realm of absolute liability for a store, doesn't it?
I think you're going down that path, but we don't have that in this case because what we also have.
I'm taking you at your argument. Sure. You said there's liquid, there's a slip, we can start piling on inferences, and away we go. Right. My question is, doesn't that legal construct seems to be if not indeed certainly in presentation to be absolute liability.
Not when you have evidence to show how liquid could have gotten there.
But you don't,
That-
right?
I do.
Where in the other than and this kind of, maybe you're calling it an inference, I'm calling it maybe a gap, but maybe you can bridge that gap. You're
Sure.
saying because Walmart sells liquid, this liquid here must have come from there, and we're missing that gap between those two, right?
The gap in between those two is the fact that there's liquid and there's slips and falls that occur with regularity at this Walmart. We have evidence in this case that there is almost, I believe I'm correct, that there's almost 60 instances of slips and falls at this particular Walmart within a gap of about 3 years prior to this fall. And so when you have a condition that occurs with regularity, the case law says that essentially fills in that gap, Judge Lucas, that you're talking about. If you can prove that there was a liquid on the
Mr. Lee, aren't you
floor,
just pretty much wildly speculating that the liquid she slipped on was sold at Walmart out of one of their vending machines? I mean, isn't it equally as likely as somebody brought in a bottle of water and spilled it, dropped it? How do we know? I mean, it's just it's an absolute guess. It's an absolute creation that the liquid that resulted in the slip came from Walmart. We don't know that. There's nothing in the record to indicate that.
we don't know that for certain, Your Honor. And
We don't know that at all.
But the case law doesn't say you have to know that. The case law does not say, and I'll take it from another instances. The case law does not say that we have to not only know that there's liquid on the floor, but we have to know where that liquid came from. The case law does not say that, because if you take the opposite of the argument I think the court's making, if the plaintiff would have to know that there was liquid on the floor, that they slipped on it, and we would have to know specifically where that liquid came from, I would venture to say the other way, almost no case would be able to go forward.
And I think, Mr. Lee, you're making a point, except that to tie Judge Black's question in with what your earlier statement was, you claim that there's an element of actual knowledge here. And that's kind of, at least where I'm like, where would that come from if you don't have any evidence that Walmart was indeed responsible for this liquid?
The
answer is no. I think where you got to land is this is a constructive knowledge case, or it's not, or it's you have no knowledge.
Well, the argument that I would make to that, Your Honor, is that you can show actual knowledge through, and it's just basically knowledge of the company, in this case Walmart, that they have knowledge of, and it's not knowledge of this particular spill. It's knowledge that there are spills that are occurring and that they are tied in some way.
Knowledge that there have been prior slips, not that there are spills occurring, right?
That's right. And so
Prior slips, is there any evidence that establishes that whatever caused this slip was similar in nature, similar in location to any of the other slips?
I don't believe so. I don't believe that there was.
At what point do you contend then that there are a sufficient number of slips to establish a heightened duty on Walmart and the imposition of constructive knowledge liability? Is it 10?
Judge Silberman, I don't know if you're asking me whether there's like a particular magic number. I don't think there is. I don't think you have to get 10 slips a year or 20 slips a year to make that. I think what it means is, and I'm kind of referring back, I think, to the Bellevue case that I cited to, the fact that there are incidents that have occurred there, and the fact that Walmart knows about those instances, that gives the jury the ability to find knowledge and find foreseeability, which is really what we're talking about.
Isn't there some indication that at least some of the claimed slips were either established as being false claims, or they could never be supported or justified by whatever information was provided?
There is some evidence of that. There's testimony from, I believe it was the manager, one of the managers at Walmart, that some of them, there was never quantified how many, but that some of them that they believed were, in their words, I believe it was actually fraudulent, the one that they used. There was no quantification of that. But to take the opposite part of that, well, then that means, even if we believe that, right? Even if the jury were to believe that, yes, there were incidents that were not really slips and was someone committing fraud, essentially, there are other ones that are, and that are legitimate slips, they're legitimate false. And again, these all occurred in the store. And so what we don't, I'm sorry, go ahead.
The store is a large store. And
Yeah.
It does not surprise me, sad as it may be, it does not surprise me that there might be slips at the entryway when it's raining. There may be slips by each of the restaurants. If it has a freezer and refrigerator section, there might be slips there. There might be slips in the laundry aisle. There could be slips in a whole range of locations. And so I think, at least for me, the question is, what suggests that Walmart knew or likely should have known that a slip in this area was going to happen on this day and time, and this woman's the one who fell?
Okay. Yes. Are you asking me does that mean that they have to, for the other parts of the store? Is that what you're saying, Your Honor?
For purposes of constructive notice, does there have to be any similarity between prior falls, or is it enough if out of 54 falls or claimed falls, if 53 of them occurred at one of the restaurants and one occurred in the laundry aisle, what puts Walmart on constructive notice or actual notice that this particular slip was an accident waiting to happen?
I think my argument, Your Honor, is that it doesn't matter where the slip is.
Okay, so it's a certain number of slips in a given location in a given restaurant or a given store is going to now turn it into essentially a strict liability situation for any future slips, unless the defense can show that the person who slipped saw the puddle and intentionally walked through it.
I don't believe it turns into a strict liability. I believe that because we're talking really, when we talk about how many incidents there are, where they are, what they are, we're talking about foreseeability of transitory foreign substances. That's really what we're talking about. And it doesn't matter.
Correct me if I'm wrong, but Mr. Lee, my memory is that there's nothing in the record to indicate that any of those former slips were anywhere near the one that's involved in this case.
There's nothing in the record that says that, Your Honor, but my argument is that you don't need to.
I understand your argument, but in other words, where this slip and fall occurred, there's nothing peculiar about that area that lends itself to a number of these type of incidents. In fact, the opposite is the case, that there was nothing to indicate that any of the prior slips had occurred in or around where this one occurred.
I agree with you, Your Honor. I don't think there is evidence as to where these occurred on any of them. What I would come back to is actually what was written in the Bellevue case from this court. And again, I know that was dealing with an assault and those type of issues, but in the Bellevue case, when the court was talking about the incidents, there were some instances in that case that were outside of the establishment, that were down the street. And what this court said, we talk about admissibility now at trial. It says it should not be based on whether it occurred within the four walls of Frenchie's, that was the place, or whether it was similar to what occurred in this case. Rather, it must be based on whether or not the event put Frenchie's on notice that the attack, in that case, resulting in Miss Bellevue's injury was foreseeable.
I think you're quoting me, Mr. Lee. I think you're quoting me, if I'm not mistaken. Isn't that what I wrote?
I think you did, Judge.
And I don't think the slip and fall at Walmart is the same as an assault outside of Frenchie's, but I appreciate you using the case that I authored, but I don't think it applies here.
Well, I think the concept does, Judge. And the reason why I say that is because I see it the other way. If the court were to hold that, well, we have to have a similar instance in the electronics section at Walmart. We have to have a fall. We have to have a transitory foreign substance in the Walmart electronics section for Walmart to have constructive notice that could happen in the electronics section. And therefore, everything else, any slip and fall that occurred in any other place has no bearing on that. I don't believe that the court wants to go that far because of the fact that not only is our slip and falls prevalent specifically at this Walmart, but also Walmart themselves are giving customers substances. Now, whether or not that it goes as far as the slips and falls were specifically the substances or not, I understand that. But when I don't believe that the law says that you have to have knowledge about the specific place, and that has to be the same place as the fall to then have for them the store to have constructive knowledge. I don't believe the law says that. I don't believe this court has said that.
Mr. Lee, to my question then, if we were to write an opinion reversing and adopting the analysis that you're providing, then that opinion should put Walmart on notice that all future slips and falls in this particular store will be their responsibility and liability, absent some showing that the claimant knowingly walked through a dangerous area or a wet area.
I believe that this court can write an opinion that says that because of what the evidence is in this case, because of the fact that there is these incidents that have occurred, Walmart has constructive notice that slips happen. And because of that, they have to do various things to control that. Again, we haven't gotten to the point where the other evidences of the case, where there's been no inspections that we have talked about. It's not just that fact that we're talking about. We're talking about the whole of the evidence in this case. And the fact that there's employees there are people that came through. All that comes together. So to say that the opinion would have to say that just because there's a slip, that means Walmart is liable, which I believe is what the court's going to for that. That's a different situation. We're not talking about a trial. We're talking about a summary judgment. All we're saying is that if there is that evidence, which is the evidence in this case, it should go to a jury. The jury makes the decision, we believe, of whether or not it was reasonable for Walmart to do what they did or not, whether that really was constructive notice, which should give them liability or not. So we're not talking about, I apologize.
You're at the 3-minute mark. If you
Okay, I'll go ahead and reserve the rest of my time.
Very
Thank
good.
you.
Mr. Boland?
Yes, Your Honor. May it please the court. I believe that the panel has focused exactly on the very issues that make this case a proper granting of a summary judgment. Specifically the statute under 768 that relates to transitory foreign substances, it puts the duty or the burden on the plaintiff to prove not only negligent maintenance, but also actual or constructive knowledge. And so I would respectfully submit where the plaintiff's argument fails is that they do not want to connect those two things, which is required under the statute. And
Mr. Boland, what you just started with troubles me, because isn't the burden for summary judgment the burden of your client?
it is, Your Honor. And what the case law says is that if we prove that there is no issue of material fact, then the burden shifts back for the responsive party, in this case the plaintiff, to then show that there is an issue of material fact for the jury.
What about the adequacy of inspections and cleaning of the store? Is that a burden that Walmart has to bear in order to obtain summary judgment?
I don't believe so, Your Honor. I believe that while there is a duty to maintain the store in a reasonable fashion, there has to be some issue of material fact that Walmart failed in that duty. And just suggesting, for example, that there may not have been an inspection in a set period of time certainly doesn't rise to the level of whether or not it was a reasonable maintenance of the store. But even if we were to conclude, for the purposes of summary judgment, even if we were to conclude that the maintenance of the store was unreasonable, because we are dealing with a transitory foreign substance, the plaintiff still must show actual or constructive knowledge of the substance. And that's why, for example, the Bellevue case is not analogous, and it cannot be used, the analysis can't be used in this case. That was a negligent security case. So foreseeability in that instance is a relevant factor to determine whether or not someone is on notice that, for example, in that case, an assault can take place. But the Florida legislature has specifically set forth a statute when it deals specifically with transitory foreign substances that says actual or constructive notice must be shown. And in this case, there's a complete absence of that.
Walmart has presented evidence, which it has in this case, of what its standard protocols are. Well, let me ask it this way. Was there evidence that the protocols were followed in this particular situation? Or was it here are what our standard protocols are, period?
Correct, Judge. The record evidence in this case show what the policies and procedures were, but there is no evidence in the record of a violation of those policies and procedures. And that, the fact that there was a violation is stated within some of the filings of the appellant, but there is no record evidence. There's no citation to any record evidence that suggests that they were violated.
So is the burden on Walmart to establish that the protocols were followed on that day, or is it the burden of the plaintiff to show that there was some lapse in those policies?
It's the burden of Walmart to show that there's no issue of material fact as it relates to that issue within the record. And as of the time of summary judgment, and this argument was made to the trial court at the time of summary judgment, there was no evidence of a violation of the policy or procedure set forth by Walmart. And I would go on to say, Judge, that the case law, specifically the Whitkey case, which is a Walmart case as well, in that case, the policies and procedures were used to try and make the argument that Walmart failed to meet the standard of care as it related to maintenance of the store. And the decision to allow that evidence to carry the day was overturned by the appellate court, because what the appellate court said was that the policies and procedures, there was no evidence that those set the standard of care, and that we were, now shifting the standard of care to something that was perhaps higher than what is a reasonable standard. And so unless there is evidence not only of a violation of the policy and procedure, but also that the policy and procedure establishes the standard of care, then that fact in and of itself cannot be evidence of a failure to reasonably maintain the store.
So your position is that even if Walmart had no policies and protocols in place, there would still have to be some evidence that the substance was there long enough to have been noticed?
Absolutely, Judge. And I think that's under 768. That's exactly what that statute says, is that even though it does not alleviate or relieve the burden under common law, which is to maintain the store reasonably, there still has to be, if it's a transitory foreign substance, the plaintiff still is required to prove actual or constructive knowledge. And in this case, I think the court has probed this sufficiently, but in this case, there is no evidence of actual knowledge. And the fact that there are drinks sold in the store is analogous to the fact that Walmart also sells water bottles within the store. And so there's always going to be liquids in a store like this, Winn-Dixie, Publix, Walmart, whatever the store may be. And so certainly the law doesn't suggest that if there are liquids anywhere within the store, then the plaintiff is permitted to make a leap from that liquid to placing that liquid on the floor. And in this case, there is not only no evidence whatsoever that there was any individual who carried a drink past the area. And again, as Judge Black noted, there is video evidence of this area at the time of the fall. There's no evidence that anybody carried a drink past the area. There's no evidence that the water or the liquid that was found on the floor, in fact, came from a drink that was sold within the store. And the evidence in the record even went further to suggest that there wasn't any cap or cup or straw or any solid waste product found anywhere around the area. So there is simply the record and the evidence is completely devoid of any fact that would suggest that it came from a drink that was sold inside of Walmart. But I think we can even go further than that when we start talking about what the evidence shows regarding whether or not there would be any suggestion that such an event has ever taken place in that area. And Judge, I think you're quite right that when we're talking about a store that's several thousand square feet, context matters. And so if there is a slip and fall, for example, because of a leaky pipe in the bathroom, there might be 5 incidents of that in a bathroom. And if this incident took place in the bathroom, then perhaps those might be sufficiently similar enough to be admissible. But there certainly cannot be any suggestion that the electronics department, which is where this incident took place, should somehow be on notice of a potentially water on the floor because it took place in the bathroom. That's just it's too far of a logical leap. And when we start looking at the cases that the appellant cited in support of their argument, it actually shows specifically what we're trying to argue. The Maryland maintenance case, for example, is a situation in which there was a host of evidence that the area, as it was a racetrack, the area which the plaintiff fell, there was multiple witnesses who testified that area was quote unquote sloppy. It was never maintained, and that the maintenance people never went into that area to clean it, even though there was knowledge that it was dirty. We don't have that. Not only do we not have an alleged slip and fall in the electronics department, there isn't even any evidence in this case that there had ever been an alleged dangerous condition in the department. In other words, no one said, yeah, we've had situations where people have come to us and said, there's water on the floor that needs to be cleaned up before an incident took place. So, the prior incidents, and this court is correct, of the 54 reported incidents in over a 3-year period of time in a store the size of Walmart, some of them were found to be fraudulent. And there isn't any evidence that that any of them happened, or that the substance that was allegedly on the floor was the same substance or a similar substance to what the plaintiff fell on. But none of them occurred in the electronics department or immediately surrounding it. And the cases that we have cited in support of our motion, speak to the level of evidence that is required for constructive notice and constructive knowledge. In this case, there isn't any evidence that any of the Walmart employees, for example, were close enough to the spill or saw the area with respect to the time period in which the plaintiff fell, where they should have discovered this spill. Cases like the ones that were cited in the brief even go so far as to having employees of the store in the very same aisle as where the incident took place. And the court said, without there being some evidence that they looked in that direction or they could have seen it, it's not enough to establish constructive notice. Our case is even more remote, that anybody who is even seen on the video is several aisles away from where this incident took place. So for those reasons, I do not believe that the record has any suggestion that there is either actual or constructive knowledge sufficient to survive summary judgment, and respectfully would request that the summary judgment be upheld.
Very good. Thank you. Mr. Lee, you have 3 minutes for rebuttal.
Thank you, Your Honor. I just wanted to touch on the inspection part, because that was something that was talked about. The store video does show employees of Walmart in the area and looking in the area and stocking and doing various things like mopping, and that can be evidence that can be shown to show improper inspection. Just because Walmart has a policy and procedure of doing inspections, and their policies and procedures say they should be doing it constantly. That's what the policy procedure is. We have evidence from the video that they weren't doing that. And so that is evidence that can go to a jury to show that the inspection was inadequate. The argument that has been said is that, well, the size of the store means that almost that we get a pass and not having this part of the store be as safe as this part of the store. And the size of the store should not matter to this court, whether it is a 1,000 square foot restaurant or a store versus a 10,000 foot restaurant or store. There is nothing in the premises liability law that allows the 10,000-foot Walmart store to have less of a duty than the 1,000-foot store. They have the same duty. Do they have to have more people to comply with that duty? Sure. Do they have to have a robust policy and procedure? Do they have to follow it? Absolutely. But the size of the store should not matter for this court's consideration, because of the fact then you would really be going down a road that the bigger the store, the less of the duty. I don't think that's what this court wants to go down. We believe that at the very least, there was ample evidence of constructive notice of Walmart of this condition or conditions such as it, so as it could go to a jury. This court doesn't have to determine whether or not a jury is going to believe the plaintiff or believe Walmart. All this court has to do is look at the facts as it sits in a summary judgment posture. And we believe that if the court does that, then this summary judgment should be reversed. If there's any other questions, I will certainly answer them. But other than that, thank you for your time today.
Very good. Thank you very much, Mr. Lee and Mr. Boland. You may exit the courtroom. The next case